So you might be watching this thinking about divorce and how you would go about it. Well, who better to explain the ins and the outs than Suzanne Foster, who joins me now. She's a senior solicitor here at KJ Smith. Tell me a little bit about how I would go about it if I was thinking about it. What are the first steps, as it were?
If you're thinking about divorce, it has to be on the basis that your marriage has irretrievably broken down. That is the one ground, and that's what you have to convince the district judge of. There are 5 factors that you can rely on to prove that irretrievable breakdown, and that is unreasonable behaviour, adultery, 2 years separation with consent, 5 years separation, or desertion. And if you want to be the petitioner, then you have to have one of those factors to be able to prove that irretrievable breakdown.
And what constitutes unreasonable behaviour?
Behaviour that you as the petitioner consider unreasonable. That can be on the mild end of the spectrum, and we do try and keep it very mild. This is not about point scoring against the other side and making it very difficult in an already emotionally charged situation. So it is something that you feel you can no longer continue to live with.
Now, a lot of people talk about resolution as another option. Can you tell me exactly what is resolution?
Resolution is the formerly known as the Solicitors Family Law Association, and it's an organisation that family lawyers are members of, where we sign up to a code of conduct where we promise to deal with family matters in a constructive way but non-confrontationally, and to keep things as amicable as possible. Separation is an extremely emotionally charged situation for the parties going through it, and it's up to the solicitor to try and keep things on an even keel and to keep things amicable so that there is the ability to reach agreement going forward.
Sometimes it can all seem quite overwhelming and quite complicated. Can you talk me through the process of divorce and what kind of stages it goes through?
The first stage would be to draft the divorce petition. That always gets approved by the petitioner prior to it going anywhere. You need to be comfortable with what is being put as the reason for the breakdown of the marriage. You then, once the draft is approved by the petitioner, it is a resolution protocol to provide the respondent, that is the other party, with a copy of the draft divorce petition. That gives the other party an opportunity to take legal advice at an early stage, and it avoids the respondent receiving the paperwork from the court as the first thing they know about the proceedings. So again, it's an attempt to keep things as amicable as possible. Once the respondents have the opportunity to consider the draft petition, it's then sent to the court, and that's known as being issued. The court will deal with and issue the petition, where a court fee is payable. The court is then responsible for sending the issued petition to the respondent, which is done by first-class post. The respondent then has a time frame to complete an acknowledgement of service, and depending on whether the petition is to be defended or allowed to go through on an undefended basis, depends on how the respondent completes that acknowledgement. Again, the acknowledgement is returned to the court, and that's known as filing with the court. The next procedure is for the petitioner to apply for decree nisi. Once the decree nisi is pronounced, you must wait at least 6 weeks and 1 day before you can apply for the decree absolute, and it's then up to the petitioner after that period has expired to apply for the absolute. It is common that the application for absolute is delayed until the finances are agreed between the parties.
Interesting. To that point, so let's say I came to you and my other half had obtained a decree nisi but won't apply for a decree absolute. What can I do?
If you're the respondent and the petitioner hasn't applied for the decree absolute, but you have a financial settlement and it's all agreed and resolved, as long as there's been a further 3 months after the 6 weeks that the petitioner had to apply for the absolute, it is possible for the respondent to apply for the absolute. So that's a time frame of 4.5 months after nisi, as long as you have a financial settlement. As the respondent, if you make an application for decree absolute, the court would list it for a short hearing to hear both parties to determine whether or not the absolute should be pronounced.
So if I'm coming to you and I'd like to know roughly how long my divorce would take, I know it's quite difficult to predict, but roughly if things went smoothly, how long would I be looking at?
The entire process can be completed within 5 to 6 months, but it can take longer if the financial issues take longer to agree or if there are children involved.
And Suzanne, tell me, you know, if I'm in a situation where I don't agree to a divorce, what do I do then?
If the petition has already been issued at court and you've received the paperwork, you have to complete the acknowledgement of service. If you don't complete the acknowledgement of service and simply ignore, it is possible that the petitioner could still apply for the divorce to continue without your involvement. So to avoid that, you should take legal advice at an early stage. There are options available to you, and so taking legal advice will enable you to establish what those options are, and you can decide which is the best route. It is possible that you could apply to defend the petition, but again, there are cost implications with that, and it could be that you're creating animosity in a situation where, if you have the situation properly explained to you, what the other side is trying to achieve and what the outcomes can be, it might not be as bad as you initially think, and your initial reaction might be to oppose it and to try and defend it. But if it's properly explained to you, you may find that there are other options available to you.
Suzanne, it's been a pleasure talking to you. Thank you very much indeed for joining us.